Good afternoon, everyone, and welcome to our webinar, Navigating the New Normal, the Post-Pandemic Workplace and Hot Topics. Please take a moment to read the information slide that's on your screen while I introduce our speakers today. I'm Todd. I'm a partner in Fasken's Labor, Employment and Human Rights Group. I'm based in the Toronto office. I'm joined today by my Toronto colleagues, Katherine Pollock, my partner and chair of our partnership board, Alix, also my partner, and Rachel Younan, yet another one of my partners, all here in Toronto. And now on to our presentation. We have a relatively full agenda here today. We're going to talk about some new Ontario legislation for workers on digital platforms, and we'll place that in context as part of a larger trend towards regulation of gig work across Canada and overseas. We'll talk about some recent changes in employment standards, health and safety laws, and take a brief look at the new right to disconnect policy requirements in Ontario. If you're particularly interested in that topic, you'll want to register for our May 3rd panel on disconnecting from work requirements. It's a focused conversation, an hour and a half, all on that topic. Finally, today we're going to talk about working in a post-pandemic workplace. So on to our first topic, which is really a series of topics that has been conveniently packaged by the government in Ontario into one piece of legislation. It's Bill 88. And in brief, what it does is make a number of significant changes to employment and labor laws in Ontario. When the Minister of Labor introduced it in February, he said, this is how we're protecting workers. We're helping them earn bigger paychecks and giving them greater opportunities right here in Ontario. And that might help you put this in context. We are approaching a provincial election on June 2nd of 2022. And so we have to look at these amendments in that context. The bill's broken up into 4 schedules or parts, and each schedule deals with a different piece of legislation. And you see them here listed on your screen. Let's start with the Digital Platform Workers' Rights Act. Digital platform work is a part of everyday life. You may have used it today to order your breakfast, to get a ride to the office, or maybe you had someone build your IKEA dresser on the weekend. You can use it for countless different tasks. And it should be no surprise that there are hundreds of these digital platforms now. We've seen a 5-fold increase in digital labor platforms since 2010. Back in 2010, there was about 100. Now we're talking about 777. We've seen a related increase in the number of workers who are providing services on these platforms. Before the pandemic, around 8% of Canadians had participated in gig work, and that was a 2016 statistic. Estimates vary now, but according to some, it's doubled. It's in the 13 to 16% of Canadian adults have participated in the gig economy. And even more Canadian businesses have participated. 1 in 3 are using digital platforms to hire workers. Part of this growth is related to the pandemic. Many businesses were closed, either fully or partially. And we also saw an increase in demand for certain types of work, like delivery. So there was an increase in demand for gig-based work. It's a new way of doing business and a new way of working. From our perspective as labor and employment lawyers, it's reorganized things. It's taken what would traditionally have relied on employment relationships and structured it differently. Work is now on demand rather than at scheduled times. Compensation is piece rate rather than by hour or by salary. It's now done by independent contractors or people who are self-employed instead of by employees. There are some well-documented advantages for workers. You get flexible schedules. You can choose when and where you work. You can work anytime, anywhere. And there's not really a significant investment in assets to start work. You need a mobile phone, an internet plan to connect. For businesses, there's an opportunity to broaden your customer base, to increase your labor supply, and improve revenue and productivity. But from a legal perspective, there are questions and sometimes disputes about whether these people who are providing their services as gig workers are employees, and whether and how our traditional labor and employment laws should apply to these people, if at all. And there's really been no clear consensus on the status of gig workers. Gig workers who thought they were employees and entitled to protections of our employment and labor laws, in many cases were required to litigate to seek those rights. What we see now is that's changing. Ontario has now passed the Digital Platform Workers' Right Act, giving certain rights to digital workers. You'll see on the next slide that Ontario is the first province in Canada to pass this type of legislation. We may not be the last. In 2019, the federal government established an expert panel on modern federal labor standards, which looked at lots of things, but particularly about non-standard workers, and considered whether we needed to make changes to Part 3 of the Canada Labour Code to cover these non-standard workers or gig workers. One of the recommendations that was made is that a definition of employee be added to the legislation that included the concept of dependent contractors, people who were quasi-contractors, but who were economically or financially dependent on one principal, like many gig workers. This is part of a global trend towards regulation of the gig economy. We've seen legislation in France, we've seen recommendations in the UK, and more recently, the European Commission proposed a package of reforms to regulate digital labor work. They outlined a series of criteria to specify when a platform would be considered an employer, and if at least two of those criteria were met, then that platform would be an employer, and the people who perform services on the platform would be employees entitled to traditional labor and employment rights. Other jurisdictions are taking a different approach, like Ontario. They're giving workers certain rights, but not all the rights you would expect that come with employment. The Digital Platform Rights Act on the next slide, you'll see that it has been passed, but it is not yet in force. It comes in force on a date to be proclaimed, so a date decided by the government in the future. It applies to workers who perform digital platform work, and that's a defined term. It is ride sharing, delivery, courier, or other services provided by the worker in exchange for payment, and where those work assignments are provided by an operator through the use of a digital platform. These types of workers are now going to have certain rights when the legislation comes into force. First, they have the right to information. When they start, within 24 hours of getting access to the platform, the operator is going to have to tell them certain things in writing. How will you be paid? Are we collecting tips? And if so, when and how? What are our pay periods and when is your pay date? What factors do we use to decide how you're offered work assignments? And is there a performance rating system? And if so, what are the consequences of that system for you as the gig worker? When changes are made to those areas, the operator will have to notify the worker before the changes take effect. When an assignment is offered to a worker, there's also an obligation to provide them certain information, including how much they'll be paid, how that rate was calculated, how the operator made the decision to offer the work to that person, and whether there will be consequences if the worker declines that work. And if so, what are the consequences? When a work assignment is done, so the worker has accepted and done the task, when it's done within 24 hours, the operator will have to provide in writing the actual amount to be paid to the worker, how it was paid, and in addition, the amount of tips and gratuities that were collected. The operator also needs to provide information about performance rating. So if the consumers or the operator are rating the gig workers, the operator needs to provide certain information to the gig workers. The second right is the right to a recurring payday and a pay period, so that there are set periods and days on which you will be paid. The third right will be the right to a minimum wage. An operator has to pay minimum wage, in relation to each work assignment. And that can't include tips in the calculation. So it has to be for each assignment, the minimum wage under employment standards. But oh wait, there is yet more. The digital workers will have the right to their earnings. The operator can't withhold or deduct from those earnings or from their tips unless they're authorized to by the Act or by a court order. That's similar to protections we see in employment standards legislation for workers. There's a right to notice of removal from the platform. An operator has to give a written explanation of why access is being removed from a worker. And if that removal is going to be for more than 24 hours, the worker has to be given 2 weeks prior written notice of the removal, similar to providing advance notice of termination. There's also a right to dispute resolution in Ontario. So the disputes have to be settled here in Ontario. They can't be international arbitration panels appointed in the Netherlands, in the UK, in California. If there's a dispute, it has to be decided here in Ontario. And the final right is the right for workers to be free from reprisal. So it'll be prohibited for an operator to intimidate, penalize, or attempt to intimidate or penalize a worker for enforcing any of these rights. Along with these rights come obligations on the employer. The employer must make and keep certain records about workers and have them available for inspection. And of course, that means that there will be new compliance officers under the Act. They're going to have broad duties to enforce the Act proactively, to come to an operator's workplace and say, I want to see your records. And they can also come in response to complaints by workers. When the compliance officers do come, they'll have the right to enter a place of business that's not a residence during working hours, to conduct an inspection for compliance, to look at records, to require production of things, and to make and keep copies of information. There's going to be a related obligation on individuals to assist the officer in their duties. And related to that, a prohibition on obstructing the officer. Compliance officers will be able to make orders to comply with the Act if they find instances of non-compliance. They'll have the power to order operators to pay amounts that they decide are owing to gig workers. And directors of the operators, the corporate directors of the operators, are jointly and severally liable for those amounts in certain situations. There will be a right to apply for review of certain orders that are made under the Act, and those will be heard by the Ontario Labour Relations Board. There's a couple of other provisions I want to draw to your attention. It's a complete Act, it's very detailed, but two other things that I think warrant special mention. The first is that there's a name and shame provision. So it allows the regulator to publish notice of contravention, including on the internet. So if an operator has breached the Act, it can be published. There's also a limited bar on civil actions. So if a worker files a complaint under this new Act related to a failure to be paid, the worker cannot file a civil claim or lawsuit for the same amount unless the worker has most recently filed a complaint and within 2 weeks of filing that complaint, withdraw it. In that case, the worker can proceed with their civil claim. Bill 88 does some other things that are important for us to keep in mind. There are amendments to the Employment Standards Act. Beginning January 1st of 2023, the ESA will not apply to business consultants or IT consultants. And both of those are defined terms. Business consultants are individuals who provide advice or services to businesses in relation to certain areas. And there's a enumerated list in the Act. Things like profitability, finance, accounting, human resources. IT consultants are individuals who provide advice or services to businesses or organizations on their IT needs. So configuring, developing, testing, installing, all of those things related to information technology systems. Those are the defined terms. But there are three criteria that have to be met for either of those two buckets of people to be excluded from the Act. The business consultant or an IT consultant must provide services through a corporation of which the consultant is either a director or a shareholder who is a party to a unanimous shareholder agreement. Or they can do it as a sole proprietor. If they're doing it as a sole proprietor, it has to be their own sole proprietorship, their own business. And if it's under their business name, that business name has to be registered. There has to be an agreement specifying the consultant's services, and it has to set out the amount the consultant is paid and when they will be paid. The amount has to be set out in an hourly rate. The hourly rate has to be equal to or greater than $60 per hour, excluding bonuses, commissions, expenses, traveling allowances, and benefits. And the third criteria, the consultant actually needs to be paid the amount set out in the agreement. This amendment to the ESA also gives the government the power to add new criteria that need to be met by regulations, although none have yet been added. It also allows the government to use regulations to specify how that hourly rate, how that $60 threshold is going to be met. But as I've said, we don't yet have any regulations. There is a further amendment to the Employment Standards Act. To require employers with 25 or more employees on January 1 of each year to have a written policy in place regarding electronic monitoring of employees by March of that same year. Now, there's a transitional provision that gives 6 months after the bill receives royal assent to comply with this new requirement. So employers who had 25 or more employees on January 1 of 2020 must have their policy in place in the future. It's not now. It's not March of this year, that is to say. In subsequent years, you'll be looking at January and March of that year to decide whether or not you have to have your policy in place. If you're required to have a policy, it has to have certain things in it that are listed here on the screen. And I won't go through those in detail, but what you'll need to do is take a look at the ways that you are monitoring your employees, because the Act doesn't define what electronic monitoring is. So you'll need to identify the ways that you monitor employees. Some things are going to be obvious. You might have video surveillance. Other things might be less obvious. You might monitor email use. You might monitor computers, employee pass cards, cell phones, GPS or mileage trackers. All of those things could, depending on the circumstances, be electronic monitoring. We should also keep in mind the amendment is not specific to the workplace. It could apply to monitoring that you do in the fields or at home when people are working remotely. Keep in mind that if you have a policy already, it might be something that complies with the obligation. So you may have a privacy policy or an acceptable use policy that sets out when and how you monitor employees. And if so, it may comply, but you'll want to take a review of that policy against these requirements. You'll see on the next slide that your obligation is not just to have a policy, but to provide it to employees and to retain that policy for a certain period of time. For current employees, you have 30 days to provide it to them. New employees, you can see the timelines here on the screen. I won't go through them with you here today, but keep in mind that you have to retain copies of every written policy you've had in place for 3 years after the policy ceases to have effect. So if you're changing your policies, you're going to have to keep your policy for 3 years after it takes effect. There's 2 helpful things in these amendments to keep in mind on the next slide. The first is that the right to complain about electronic monitoring is limited to failure to provide the policy. So an employee cannot complain that they are being monitored to the Ministry of Labor. They cannot complain about that. They don't have that right. They don't have a right to complain about the employer using that information. In fact, the amendment specifies that nothing affects or limits the employer's ability to use the information obtained through monitoring. Keep in mind that there could be other restrictions on your ability to monitor and your ability to use that information. But in this particular piece of legislation, those are 2 helpful things to keep in mind. There is a further amendment to the Employment Standards Act in Ontario, effective April 11th of 2022. The government has expanded the reasons that reservist leave may be taken to include Canadian Armed Forces military skills training. And they've also reduced the length of time someone must be consecutively employed to take that leave. It used to be 6 months, and now it's been reduced to 3. Previously, reservist leave was limited to deployment, so you actually had to be deployed to take these leaves. And now it will be changed so that if you're called up for skills training, you're entitled to this leave under the Act. And all the traditional rules and obligations applicable to statutory leaves would apply to reservist leaves. There are some further changes in Bill 88 to the Fair Access to Regulated Professions and Compulsory Trades Act. In spring of 2021, there was a consultation where the government made some changes to reduce barriers for internationally trained workers, and that happened in 2021. There are further changes being made now for what are called domestic labor mobility applicants. So we're thinking about individuals who are in Canada, who are registered in another jurisdiction, not who are internationally trained. Some of those changes are immediate and others are going to be made on dates to be proclaimed. But generally, the amendments require regulated professions to respond to applications for registration from domestic applicants within 10 days and to provide a decision within 30 days, unless there is an exemption. We'll just move on to the next slide, and we'll talk about the amendments to the Occupational Health and Safety Act that are buried in Bill 88. The Occupational Health and Safety Act will be amended in July 1st of 2022 to do a number of things. First, the limitation period will be doubled from 1 to 2 years. Just let that sink in. So twice as long for the ministry to bring charges. There is an increase in the maximum fine for directors and officers to 1.5 million. There's an increase in the maximum fine for other individuals to 500,000. For directors and officers, that's a 15 times increase. For other individuals, it's a 5 times increase. Keep in mind, these are maximums and they are per offense. Keep in mind also that individuals also face jail time. They could be sentenced to up to 12 months in jail in addition to a fine. So when we're looking at these maximum fines, you could be dealing with millions or multiple millions of potential liability. The government's also amended the act to include specific aggravating factors that must be considered in sentencing. They've only added aggravating factors, only those things that would increase the penalty. There are no mitigating factors added, nothing that would decrease the penalty. There's a list of 10, and in the interest of time, I won't go through them with you, but keep in mind, these are things that the courts are now required to consider in sentencing. There's one other minor change in the sentencing provisions that allows other, quote, prescribed orders to be made in sentencing. And it's not clear what that means, but in other jurisdictions, they allow creative sentencing. So a judge may decide that someone should make a donation to charity or set up a training fund in relation to a health and safety offense. And that raises the prospect that this may now happen in Ontario, although it's not clear. On a date to be proclaimed, so in the future at some point, there will now be a new duty for employers to provide and maintain in good condition a naloxone kit in the workplace where the employer is aware or ought reasonably to be aware that there's a risk of a worker having an opioid overdose at a workplace where they're working. The kit has to contain certain prescribed contents. The ministry has said that this is intended to apply to what they call high-risk workplaces, and they say construction sites, bars, and nightclubs, but it's broader than that, and it would apply anywhere there is a risk of overdose. If required to have the kit, the employer has to ensure that at any time there are workers in the workplace, that the naloxone kit is in the charge of a trained worker working in the vicinity of the kit. They'll have to have received specific training, and it's going to be more extensive than how to use the kit. They have to be able to recognize the signs of an overdose. They have to understand how to administer naloxone, and they have to understand and be trained on the hazards related to administering naloxone. That's not specified. The types of hazard aren't specified, but we're thinking likely things like you would want first aid training for your workers. They may need training on dealing with violent or agitated individuals. They may need training on dealing with sharps or needles. They may need precautions for dealing or training on precautions for dealing with blood and bodily fluids. All of those things they may need training on. Implicit in all of this is the obligation that other people who are not trained should not have access to the kit. There are two other further developments on the screen for you that you should keep in mind that are coming down in Ontario. In the interest of time, I'll pass things over to Katherine Pollock, who's going to talk about changes in non-competition terms in Ontario.
Thanks, Shane. So more change afoot as at the end of last year. The Ontario government amended the Employment Standards Act to deal with non-competition clauses. Not something that any of us in our group had thought was particularly in need of change. And as I was listening to Shane, I was thinking the same thing in some of the amendments. For example, why are business consultants no longer covered by the Employment Standards Act, or IT consultants? It wasn't clear to me what was driving that change necessarily. But let's just take a look at non-competition clauses historically. They've been there to protect employers, essentially, the trade secrets of employers, the customer bases of employers, and the market share of employers. If we look at non-compete clauses through the lens of case law, we see a desire to protect employers and a desire to protect employees. In the US in particular, the non-competition clauses have been thought to prevent unfairness between employers. Employer A hires and pays somebody for many years and infuses that person with trade secrets and confidential information, all at the expense of employer number A. That employee moves over to employer number B, and employer B gets to take advantage of all of that information and all of that effort that was put into that employee through employer A. And it was thought it's not fair to employer A that the employee can move over to employer B. And so in the US, non-competes have been much more on average upheld because of this desire to be fair, particularly to employer A. That's not really the lens through which we've looked at things in any Canadian jurisdiction. We've looked at the lens more through what's fair to an employee. And it's not fair to an employee in my example that, so I've worked for you for 10 years or so, and you've paid me and I've learned a lot, and it's now time for me to leave. Either you've terminated my employment or I've resigned. Why should I be prevented from working in a space that I know? So the purpose of non-competes differ depending on where we are. But we know that courts prior to December 2021 were very reluctant to enforce non-compete provisions. In a sale of the business situation, that's different. Courts have always been open to enforce non-competes. But non-compete covenants for other instances that are not sale of business have not been enforced, have been thought to be void from the beginning by many courts. So, for example, courts will say if a non-solicitation will suffice to protect an employer, then that's what you should use, not a non-compete. If a good confidentiality provision is in place, that's what you should use. You don't need a non-compete. So prior to the amendments, which I'm about to discuss, it was the case in courts that most non-competes would be struck down by courts of law. Void ab initio is the good Latin term, void from the start, unless there was some exceptional reason why the employer could prove to the court, yeah, you need a non-compete. And then non-competes would only be enforceable if they were reasonable as to the length of time, the geographic scope, the geographic area and the scope. So that analysis would be undertaken, and sometimes non-competes would be upheld, but in the main, mainly only for senior management employees. So just turning to our next slide, what the Ontario government has done through the amendment to the Employment Standards Act is essentially brought to an end non-compete provisions in agreements for the following reasons: to help workers in Ontario to advance their careers and earn more money, to give the province a competitive advantage in attracting global talent, and also to make sure that employers still can protect their intellectual property through these narrower clauses. So that's sort of the background bump from the Ontario government as to why there is this prohibition. And looking at the next slide, we'll see what the government has decided to prohibit. So it prohibits both employers and employees from entering into an agreement or any part of an agreement, so not necessarily just employment, that includes a non-compete clause that prohibits the employee from engaging in, you'll see, any business or work or occupation or other activity that is in competition with the employer's business after the employment relationship ends. So it doesn't require a termination of employment from the employer to the employee. It's the ending of any employment relationship. And a non-compete clause that seeks to prohibit an employee from engaging in something in competition is now prohibited, except in a couple of instances. One is within the context of a sale of business, which has always been an exemption that's out there. And the other is with defined executive employees. Next slide, please. So here's a little more precisely the two exceptions that we're talking about. The first bullet point is if an employee sells or leases a business to employer B, and then immediately after that sale becomes an employee of that business, it's okay for the purchaser of the business to have a non-compete clause in respect of that employee. That's completely acceptable. It makes sense because it would be unfair for the employee to accept the benefit of having sold the business and then go off and compete, having rid himself or herself of the business. So that makes good intuitive sense. The other exception to the prohibition is interesting and I think was unexpected by us anyways. And that is non-competes are prohibited in any Ontario agreement except in respect of an employee who is an executive of the employer's business. And you'll see the executive is defined under the Act to mean the holder of any chief executive position. And they mean just that, chief executive officer, president, and then any of the other chiefs, administrative officer, operations, finance, IT, legal, chief human resources officer. Those are the C-suite positions where you are permitted to have where you are permitted to have a non-compete provision in place. Next slide, please. Before I get to that, to this case, which is kind of important, I just want to comment for a moment on the definition of executive and what that means. I wonder if we've sort of changed the way that we're going to look at non-competes now, because prior to this amendment to the Employment Standards Act, if a client came to, I think, any of us in the group and said, you know, we're thinking of hiring this person and she has a non-compete, what do you think? I would almost always start my analysis by saying it's almost certainly null and void, because, you know, if there's a non-solicit in place or a confidentiality provision, non-competes are hated and have been disliked very much by the courts for many, many years now. I repeat the Latin term null ab initio, null from the start, unless there's some kind of extraordinary reason why. So most of my analysis would be, I don't think it's enforceable. Now I wonder, though, with the Ontario government saying non-competes are permissible for C-suite executives, if we can now point to that as support for enforcing non-competes. I just wonder if the way in which we look at non-competes is going to change, and it's going to be easier to enforce against chief executive officer chiefs, because there it is in the Employment Standards Act. Don't know. Let's stay tuned for that. Certainly, non-competes for anybody else below the level of a C-suite are gone. That much is clear. One of the issues, and this is the case that's up on the screen right now, the Schechter case. One of the issues when the legislation came into effect at the end of last year was, well, what about all of those agreements that are out there that have non-compete provisions in them, including for people who are not in the C-suite. Are they going to be enforceable? It's not been extensive case law, but we do have this case law, which has pretty much been, I think, held by us to, yeah, this is setting the standard. Any non-compete agreement that's entered into after October 25, 2021, for anybody not at the C-suite, is going to be offside the Employment Standards Act. But any non-compete covenant that was entered into prior to October 25, 2021 is not null and void simply because of the Employment Standards Act. So there's still opportunities to make arguments for the older agreements that are in place. I'm not sure I would spend that much time agonizing over it, though, because I still think the strong preference of courts is to not enforce non-competes. They're thought to be unfair to, particularly to employees, and especially where you, the employer, have terminated the employee, and especially where you, the employer, have terminated the employee and tried to, for example, limit entitlement to just Employment Standards Act notice and then try to impose a 6 or a 12-month non-compete. Those are going to be frowned upon by our courts. So that kind of line in the sand is October 25, 2021. What's still allowed, and this is looking at the next slide, I've actually had quite a few calls from clients who have heard about the changes to the Employment Standards Act and have worried that perhaps all restrictive covenants have been somehow done away for anybody who's not in the C-suite. And that's not the case, I'm glad to report. So restrictive covenants like, I'll just focus on non-solicitation for a moment. Non-solicitation covenants are still permitted and can be used to prevent departing employees from soliciting customers or clients, and also employees. You can have a good non-solicitation covenant that stops that, what might be considered to be unfair conduct or conduct. And the covenants still have to be reasonable. The non-solicit can't be forever. It's got to be for a reasonable period of time. Also, non-solicitation covenants for the seller of a business are permitted, still permitted by law. That vendor or seller of the business can't somehow go after a business's potential customers or existing clients and customers and employees. The other restrictive covenant, or the other covenant that's still permitted, are confidentiality covenants. A really well-drafted covenant can be used to prevent misuse and disclosure of trade secrets and other confidential information. You want to make sure that the express terms that are in your agreements are clearly defined what is confidential information. And then you want to make sure that as an employer, you're treating what you say is confidential. Make sure you're treating it confidentially. So a stamp of confidential on it, for example, those sorts of things to make clear that what you say is confidential information is actually treated that way. So just a couple of final takeaways from this bit of legislation. The new statutory prohibition that I've been talking about reinforces what has been out there in the common law regarding non-competes and employment agreements. Such covenants are generally not enforceable, and the Employment Standards Act has made completely clear that, in fact, they are not enforceable unless they are in respect of the C-suite or unless they're in connection with the sale of the business. We just remind our clients the importance of well-written contractual provisions to say what you mean, to protect what you need to protect and what you're allowed to protect. That context is very important. So thank you for listening to me on this point. I will be back, time permitting, at the end of our session with you to ask some questions that have been coming in from the audience throughout our presentation today. So look forward to seeing you towards the end. Now over to Rachel.
Actually, it's Alix. Thanks, Catherine. But you can call me Rachel if you want. Hello, everyone. I'm going to talk briefly on the right to disconnect. And obviously, there's been a lot of press about this. So I thought it might just be helpful to kind of put it into context about what we're talking about when we talk about the right to disconnect. I think we've all kind of acknowledged that many employees with working from home, where their job allows them to do that, have often resulted in working longer hours at home, and there being less separation between the work and personal lives of the employees. And even before the pandemic, long working hours was seen as a serious health concern. A global study that was conducted by the World Health Organization and the International Labor Organization found that 745,000 employees died from stroke and heart disease due to long working hours in 2016. And this study really took place between 2000 and 2016. And they came out of that study sort of saying that employees who work more than 55 hours a week, were at serious risk of having a serious medical issue. And obviously, the stats in the study didn't include sort of the impact of COVID-19. But what World Health Organization's researchers have said is that the increase in remote working hours may further increase the risks that employees have. And obviously, the impact of that is, employees can often complain about burnout, low productivity, absenteeism, anxiety, chronic stress, and obviously depression. We've obviously even seen, through the pandemic, the increase in, mental health for many employees. And the impact of these medical conditions is that you have obviously retention issues, you lose employees, it lowers the workplace morale, and it can obviously prove quite costly for employees to run their business. And as an employment lawyer, what we've often seen is disability claims, human rights cases where people don't feel that their employers have accommodated them appropriately. Those are all high cost issues. So I think there's always been a recognition that even before the pandemic, that some level of disconnection from work was important to overall health. And what we've seen through the pandemic is this has become a more focused approach. And I thought it would be interesting to just consider sort of what's happening in the world around this, just briefly, and where we've seen this sort of right to disconnect emerge. It actually happened in France initially, which is interesting because they had a 2004 decision that led them to include in their civil code the idea of having to negotiate agreements with unions and work councils to allow employees to disconnect from work technology after hours. This is obviously pre-pandemic. Now, there was no penalty for employers, but obviously employers could be responsible for paying for more work that was done because it was after hours. And they also found that if the parties did not reach an agreement, the employer must nevertheless put in a policy about the use of after-hour technology. But it was really up to the employer to implement the policy. Then we had the pandemic. And I think what we've seen in a number of European countries is this recognition, as I just sort of mentioned, that there needs to be some sort of disconnect between work and home lives. And so we've seen in Belgium and Italy and Ireland and Spain, the requirement to develop a policy, which is similar to what we've seen here in Ontario, and I'll talk about that in a second. What was also interesting is Ireland has also introduced a policy that allows employees to actually request that they are able to work remotely, and employers should facilitate that as much as possible. So that's even moving a little bit ahead of just the right to disconnect. And then there's been obviously a couple places in Peru and Chile where they've really established a right to disconnect. And in those two countries, they've basically legislated that employees are not obliged to respond to communications from their employer. Now in Chile, they don't have to respond for at least 12 hours in a 24-hour period. I'm sure some of you are shocked right now. And then obviously what we've seen in Peru, that there also has to be only 8 hours in a day where they're expected to respond to their employer communications. But what's sort of clear in all the legislation is that we're really talking about communications that deal with email, phone calls, video calls, how we communicate and how that communication takes place after sort of normal working hours. And then I thought I'd just mention a couple company level initiatives that I think some of our clients would be interested to sort of hear and consider. So one that I have found particularly interesting is out of Germany, because Germany has a number of employers who have negotiated with their work councils policies around how employees can disconnect from work. And there are many big companies that have done this: Volkswagen, BMW, Daimler, the Deutsche Telekom, and some other big organizations. And so I thought I'd give you the example of what VW has taken in sort of a hard approach. And this actually occurred well before the pandemic. In 2011 and 12, they actually regulated the use of smartphones in their business. And as a result of the negotiations with their work council, which excluded managers and high-level technical experts, they basically have their servers stop working. So you cannot email between 6:15 at night and 7 a.m. the next day. I can see Shane is shaking his head in complete disbelief because, if we think about how we work in the US and Canada and North America, that just would seem it's sort of incomprehensible, but they've had this in effect for some time. And obviously exceptions can be made for specific problems, but it needs the consent of the Works Council. So that's definitely sort of one way that some businesses have sort of taken advantage of. How do we create a bit more balance between people's personal lives and work responsibilities? And the other thing that we've seen is also the use of like 4-day work weeks. And we've seen actually some examples here in Toronto where a leader, which is a software company with nearly 500 employees, is introducing a 4-day week where you maintain the benefits and the pay, but employees can now work over a 4-day week. So we're starting to see a lot of pilots coming up with that. But I think what's interesting is that when we look at all the different legislation, both in Europe, in Peru and Chile, as well as here, you start to see that the focus is really on work-related communications and technology and how that has become so prevalent and how we do our work and how our employees of different companies do their work. And so, I thought we'll turn now to Canada and we'll talk about sort of what's happening briefly at the federal level. So we know that in an effort to create greater work-life balance in Canada, the federal government is exploring this issue as well. Because right now, under the Canada Labour Code, federally regulated employees do not have a right to disconnect. But obviously, they're looking at this through the advisory committee, which was formed. And through 2020 and 2021, this committee held over 10 different meetings from a range of different experts to sort of develop what they wanted to present to the government as a way for them to contemplate how the federal legislation may work. And so they came down with sort of 3 principles federally. One is obviously employees should be paid for the work that they perform. So this will be an interesting place to go to because we think about how much work employees may do looking at emails, responding to phone calls, etc., maybe outside of work hours. We've obviously seen a lot of overtime type claims come out as class actions in some of the federal sector. So that's going to be an interesting place to see how the government moves there. The second was obviously trying to find a positive work-life balance as a goal that should help both employers and employees, right? For employers, the benefit costs are obviously increasing dramatically and have over a number of years. And obviously for employees, this has obviously created, as I said at the beginning, some serious medical issues that impact their ability to be as productive as possible. And so finally, the third principle that this report came out with, which was in February of this year, is that there needs to be some flexibility for employees and employers. And I think I've heard that a lot from my clients. When we talk about disconnecting from work, a lot of my clients are saying to me, but we give flexibility. You know, if people want to, work remotely and pick up their kid and they want to work an extra hour later, we give that type of flexibility. And so with this right to disconnect, are we going to be losing that flexibility? So that's definitely something that we're going to, that they're going to have to consider federally. So if we move to Ontario, which is our new Working for Workers Act, which was passed in December, we now know that, any employer that has 25 or more employees, I see lots of similarity to the Electronic Monitoring Act. I think the government used that as a base when they brought in that piece of new legislation. But again, the policy has to be in writing. It has to be in place 6 months after proclamation, which was December 2nd. So all these disconnect policies for Ontario employers have to be in effect by June 2nd. It's limited to work-related communications, as I mentioned before, but there's nothing about how it's going to be enforced. But what I thought is interesting, and I'll talk about the contents in a little bit more detail, is that we want to be careful about how we use the term right to disconnect, because people have been using that when I speak to them, and we've seen that a lot in the news reports when this legislation was first being introduced. And as a result, there seems to be a very strong expectation from many employees that has been told to my clients that they have the right not to work after certain hours. And that is not what the legislation is providing for. What the legislation is providing for is that you have a policy that looks at how you use your work-related communications, and you set out the expectations around that. And if, as an employer, you decide that you want to create a right where you say to employees, you have the right not to work after certain hours, then the Ministry of Labour in Ontario will enforce that right. So you want to make sure when you're drafting your policies that you've given some thought to what you as an organization needs from an operational perspective, and whether or not you're prepared to go as far as providing a right, or you want to create a policy that looks to providing a positive work-life balance and how you can achieve that. And I'll talk about that in a minute. And it's finally to finish up on the sort of Canadian context. Quebec has introduced Bill 799 in December, and that in December 2021, which would require workplaces with 100 or more employees to develop an off-duty disconnection policy. And that is typically made up of a committee where you have 50% employers and 50% employee representatives to determine how the policy is set up. For employees who have less than 100 employees, then the employer can develop the policy themselves, but it does need to get approved by the Quebec Commission. They also have penalties set out in their legislation, which can range from $2,000 to $50,000 for first offenses, depending on the size of the employer. So that's sort of the Canadian context. So just to briefly talk about the content of the policy, as I mentioned, you want to think about how you're going to balance the needs of the business and how employees and what the employees' expectations are with respect to work-related communications. I've seen a number of my clients move to acknowledging that, not to send emails out during certain times, or to have sort of disclaimer on the email to sort of say, consider, while my working hours may allow me to work later, yours may not. There's no, expectation you have to respond outside of normal business hours. So lots of employers are sort of dealing with how they want to find this balance. But as I said, you really want to think through how your workplace works, what kind of deadlines you have, what kind of operational impacts you need to consider before you create a policy, and certainly whether or not you want to create a right. More detailed conversation on this to come, lots of interesting questions being raised by our clients. A detailed review of this, if you're interested, is in our May 3rd presentation, but I definitely think you want to think about how it's going to impact your organization. So now I'll move on to talk about what's it like working in a post-pandemic workplace. we've all been talking about this for the last while, and I think we're starting to sort of realize that the future is now. We're no longer thinking about what it's going to be. That future is now, and we're 2 years into the pandemic. Workplace transformations are absolutely happening. Businesses are facing critical decisions around how do they retain one of their most important assets, and that is their people. And so, we really need to think about what is happening from an employee perspective, and then how do organizations and employers adapt to that. So I thought it'd be interesting to talk a little bit before Rachel takes on some of the legal issues about what the surveys are showing with respect to employees and how they are adjusting and readapting to work environments. So we know that the pandemic has shown that remote work is possible and employees can be highly productive. And obviously, we've seen a lot of employees indicate that they do like the flexibility of a remote workplace. And that's often important to office employees. It's not possible for some of our service-based employees who are required to attend at the workplace. If we can go to the next slide. But what we have seen in terms of the pandemic is that when we think about accommodation for employees who may have religious accommodations or family accommodations or disability-related accommodations, is that permitting them to work remotely may be something we cannot just refuse. Before the pandemic, I think lots of times my clients would say, we don't have the ability to supervise or manage people remotely, and I think that's all changed. And so you definitely want to make sure that when you're dealing with human rights related issues, that you're considering remote or hybrid work as a reasonable form of accommodation. So what we have found in the Amazon Canada survey, which came out in March 10th of this year, is that 50% of Canadian workers who work in the office scenario would prefer to work mostly or entirely remote, which is a higher number than I had anticipated. And that is more important to them than workplace culture, development and growth opportunities, and in-office perks. So how do we retain talent and attract new talent when employees have these expectations? So I thought, if we think about, over 50% of offers employees say they would prefer to either split their time equally between the office and remote, or work mostly remote. And what I've seen in a lot of the studies is that at least 3 days a week being remote seems to be a preference for at least 30% of that group. And more than half, 55% in the study, say they would be less likely to accept a job with a new employer if they mandated full-time work from the office. So again, when we think about how do we retain good talent, how do we attract new talent, you want to think about how you want to set up your remote workforce and whether or not you're prepared, whether you're going to insist on employees coming back or create a hybrid model of some kind. Because what the studies are showing is that if you want to retain workers to come into the office, many of them are going to have expectations of increased salary, more flexible work hours, more vacation entitlement, and better benefits. And those are the type of incentives employees are going to be looking for if you're going to require them to attend at the office on a full-time basis, or at least on a hybrid basis. So again, always something interesting to say. Next slide. So I thought just before we move on to some of the legal issues, this was an interesting study because it said, how many people are currently working from home? And what we've seen is that there's a real geographical difference. So if you think about Ontarians and Quebecers, they're much more likely to report that someone in their household is working from home. Whereas if we look at Atlantic Canada, Saskatchewan, and Manitoba, at least 70% are saying that no one is working from home. And that, when we think about the jobs that cannot be done remotely, we obviously think about service and retail related jobs, and typically they may be lower income households who are not able to work and have the flexibility of working from home. So something else to consider when you're looking at how you're going to deal with your workforce as a whole. And then when we looked at when we looked at office workers and we looked at the Amazon survey, what we did see was that British Columbia was most likely to have returned to the office before Omicron hit us, whereas Ontarians were the least likely to have returned to the office. And obviously what we've seen is that while almost 80% of employees in the study said they worked 5 days a week from the office before the pandemic, only 43% have returned to the office situation. So it's quite a different scenario. Can we move to the next slide? So again, if you look at across, the sort of geography of the world, you can see that 50% of employees would like to work from home 3 or more days a week. And so this is definitely not just reflected here in Canada, but we see this in other major parts of the world. Next slide, thank you. So one of the questions that many of our clients are saying to us is, what happens if you are requiring employees to come back to the office and they're refusing, and we're going to get into some of that. Rachel's going to touch on that in her presentation. But what this study shows is that, between August of 2021 and March of 2022, so if we think about just the last 6 months, right, we've seen a real change in expectations. And it may be that we're just coming out of the Omicron wave, but we really do see that, people who are agreed to just kind of go with it and return to the office dropped from 39% in August of last year to 29% in March of this year. For those who would go back to the office but start looking for a new job, we see an increase. More people are going to start looking for a new job if they're forced to go back to the workplace. And then what about employees who are likely to quit and look for another job right away? Again, we've seen an increase again from August of last year that employees are now more willing to quit and look for another job. People who are not sure, that's dropped. They have more certainty in what they want to do. So definitely these are showing that, when we look again across the world, 30% of employees are saying they're likely to switch jobs if they're required to return fully to their on-site work. Again, I think very interesting. So when we think about flexible work arrangements, what we're seeing a lot of our clients sort of dealing with is, how do you structure a hybrid model? How do you find the optimal balance between days at home versus days in the office? How do you maintain the culture of your organization? And so lots of our clients are looking at, remote work policies that have specific requirements in the policies around, what employers can expect of their employees if they're able to work remotely for at least some or all of their required work days. But there's no optimal amount of days. There's nothing that is out there that says this is what's going to work and this is not what's not going to work. I think it really depends on how your organization functions, but that flexibility is going to be key to retaining good talent, and that the conventional work week, of working Monday to Friday, 9 to 5 is not going to be as easy to convince employees that that's something that they want to do going forward. So now I'm going to turn it over to my lovely partner, Rachel Younan, who's going to talk about some of the legal issues that we're seeing emerge.
Thank you, Alix. So as Alix has just taken you through, some of these studies are I think, quite alarming to HR professionals, but I think they're fairly clear. Employees want flexibility, and we're definitely getting the sense that they want to be able to work from home. But that doesn't mean we need to toss up our hands and say everyone can work from home all the time. There are multiple ways in which you can organize your workplace, keeping in mind what employees are looking for, and at the same time tailoring what you need for your business and for your HR goals. So consider whether to have a hybrid model, as Alix was talking about, whether it's 3 days or more or less. A lot of organizations with employees working from home already may choose to adopt that hybrid model, either as a sort of transition arrangement or on a go-forward basis. Again, like Alix mentioned, there's not, a perfect number of days to work from home or from the office. Again, that's going to be really something that you have to turn your mind to as an organization. Aside from the, remote work versus in-office work models, you can also consider flexible work models. And that's really around the hours or days of work that individuals are working. So it really allows employees to customize their schedules to fit their specific needs without necessarily increasing or reducing regular hours of work or days of work. And it really recognizes that the conventional work week might not work for everyone, and also that it's not necessarily needed for your business. And so there's definitely flexibility there. Like Alix mentioned, there's still, it's really industry dependent whether or not someone can work from home on a permanent basis. And so that it's going to vary depending on where you work and where your employees are working. Ultimately, the decision that you make as an organization should be based on your business and operational needs from a post-pandemic lens. So we're often looking back at what we used to do, what the pre-pandemic workplace was like. I think we can all agree that that has changed. And that we have new goals, whether it's around business recovery or future growth or retention of employees. And so we have to sort of change our mindset and look at how we're going to move forward in a post-pandemic time. We have to weigh the positive and negative impacts of permanent remote work arrangements and think about long-term innovation, growth, employee social interaction and morale, collaboration, and generally what kind of workplace culture we want to support. And there are lots of considerations that we can turn our minds to. And as we move to the next slide, we'll focus on some of those considerations. The first really being, health and safety considerations. I think the saying here, out of sight, out of mind, might ring true. With employees working remotely, it could be very easy to forget about our duties under health and safety legislation. But at this point in our experience with the remote workforce, there's not really much excuse here. It's something that we should ensure that we've turned our minds to and make sure that we've developed organizational practices to address. Of course, in addition to all the specific duties under this legislation, we know that employers have general duties to take every precaution reasonable in the circumstances for the protection of workers. And in jurisdictions where an employer's home is considered to be an extension of the workplace, there are the requirements and duties in the occupational health and safety legislation apply. Depending on the jurisdiction, it might not be clear whether the health and safety legislation does in fact apply. For example, there are some arguments that in certain jurisdictions, the legislation might not apply. But having said that, even if there's some ambiguity there, or even if it's, definitely not, it doesn't apply, the best practice would be to take a risk management approach to health and safety to ensure that, that we are in fact taking steps to protect our employees while they're working from home. So consider if you are a national employer or you have employees in multiple jurisdictions, consider developing your protocols and systems with a view to complying with the most onerous obligations and applying those systems across your organization. Again, it might make it easier for you overall, and then you're making sure that you're meeting the sort of highest threshold or highest obligation that you have. As we move to the next slide, the next sort of obvious consideration is workers' compensation. And as we have up on the slide, the coverage requirements do vary across the country, and coverage may depend on where work is being done. But as usual, all workers' compensation boards have the right to determine if an injury or illness is in fact a workplace injury, and they'll investigate and determine an entitlement accordingly. Generally speaking, workers' compensation extends to employees as long as they're in the course of employment. And so a workers' compensation board will examine all factors, time, place, activity, to determine whether the injury or illness is work-related. As we think about workers' compensation, think about the fact that really the same rights and responsibilities apply in the event of a workplace injury that occurs at home or offsite or at the regular workplace. We have obligations to report injuries. We should take steps to obtain functional abilities information. We should, make sure employees are aware of return to work policies and protocols. And as an employer, you can consider strategies for minimizing your claim costs, including return to work scenarios where work is being done remotely. And this might be something that now we're more comfortable. To Alex's earlier point, we're in a new place where we are comfortable in our ability to have folks work from home. And so that's a real point where we can benefit from our experience and reduce costs to the organization by allowing work from home as an accommodation where there's been a workplace injury or illness. As we move to the next slide, from a human rights perspective, really, even though employees are working remotely, we still have legal obligations to accommodate an employee's needs in a timely manner when they stem from one or more of the prohibited grounds of discrimination under human rights legislation. When an employee requests accommodation and that request is related to a prohibited ground, of course, it's an employer's duty to follow the appropriate steps to ensure that that duty is met. I think at this point, it's very clear that employers have a duty to accommodate employees in relation to COVID-19, subject to the usual caveat that we have only an obligation to accommodate to the point of undue hardship. And when we think about COVID-19, this includes absences from work due to COVID itself. For a couple of years now, the Ontario Human Rights Commission has considered COVID to be a disability, and it's protected by the Human Rights Code. Other jurisdictions have followed suit or have issued similar statements, making it clear that COVID is a form of disability, and that's a medical condition, and can carry with it social stigma as well. At this point, we know a little bit more, but we still don't know about the long-term implications of someone having COVID. In most cases, we anecdotally see most employees needing only a few days or a couple of weeks off, and then they recover during that period. But think about the fact that accommodation is an individualized process, and experiences with COVID will vary. And if there's a longer period of illness or complications relating to COVID, this would need to be accommodated similar to any other medical issue. So a helpful guide up on the slide here for accommodation. So I think, just to back up a bit, I think as employers work towards a full return to an in-office work environment or some sort of hybrid model, I think we're going to see a lot of employees, to the extent that you haven't already, a lot of employees taking the position that they're unable to return to the workplace, and they're requesting to remain working from home. And there may be an instinct to reject those requests without considering the matter further. I think there's a degree of skepticism when such requests are received, and just a reminder that we really need to counteract that skepticism and turn our minds to whether there is a duty to accommodate that request based on a protected ground under human rights legislation. And the guide or broad sort of step-by-step approach outlined on the slide here can be helpful to you in working through those requests to work from home that may trigger a duty to accommodate. On the duty to accommodate, we'll remember that there's both a procedural and substantive component to that duty. Again, the procedural is the process. The substantive is the actual accommodation that's provided if there is an accommodation provided. And we'll remember that the guiding principle is that you have to accommodate to the point of undue hardship, and that the law on undue hardship is challenging most often for employers, that there's a very high threshold, and there are very limited considerations in terms of what will be considered in the undue hardship analysis. If I could just sort of comment on what I see a lot, I think in this process or in the guide up on the slide, what we often see is that employers miss out on the second step of the slide. So remember, you can ask for information. You can ask for more information. You can ask for medical documentation to help you really assess whether there is a need to provide an accommodation. In the context of folks saying that they can't come to the office, we will often see vague medical notes from a physician saying, the employee would benefit from working from home or something to that effect. Don't be shy to push back on that and to ask for better medical. Objective medical documentation should include restrictions and limitations and the duration of those restrictions and limitations. And once you have that proper information, then you can consider whether working from home is the accommodation that you need to provide, or whether there are other ways that you could accommodate the employee within the workplace. So as we go to the next slide, some general thoughts, and I'm mindful of the time, we want to get to some of your questions. Some general thoughts about sort of proactively promoting a healthy work environment. We should be encouraging clear boundaries between work life and home life wherever possible. And so we've got some ideas up on the slide here about how you might help establish some boundaries. We're hearing in the news lots of creative ideas, whether it's, the 4-day work week that Alix was mentioning earlier, or, thinking through what you want to commit to in terms of your disconnecting from work policies, lots of creative ideas that you can put in place that, are employee friendly, but frankly, and while it might seem counterintuitive, a lot of these proactive measures can help increase productivity and can help with retention and creating a supportive workplace culture, which ultimately your business or your organization will benefit from. And I think, we can take a lot of the lessons learned or approaches that we've taken during the pandemic and apply them to in-office circumstances as well. So, this isn't just for your remote workforce, but also for those who are in office. And think about how you can, actively engage your workforce, both in the office and outside of the office. There's some potential, as we have some folks returning and some remaining online, that there could be a potential that those who remain working from home could miss out on important team building or concrete work opportunities. And so we need to, again, avoid the out of sight, out of mind mentality, and really ensure that both your in-office workforce and your remote workforce are equally engaged. Let's turn to the hot button issue of policies and what you really want to have in place here as you change the way in which you're working or change how you're moving forward in this post-pandemic time. Think about putting a policy in place. It's not just because we're lawyers that we're saying you should put a policy in place. It's helpful for you. It really helps create clear expectations. So think about things like outlining who's eligible in your workforce to work from home or to have a hybrid or flexible work arrangement. Include lots of terms that give you flexibility. So approval for these kinds of remote work arrangements should be at the employer's sole discretion. You should have a process where you can modify that work arrangement. And you want to make it clear that working remotely or flexibly is a privilege and not a right. So give yourselves flexibility as an organization to make changes. To a certain extent, this is still new to a lot of us and to your organization. So as you're navigating this process, give yourself the room to breathe and room to make some changes. Practically, you need to be thoughtful about constructive dismissal risks. Outline flexibility in your policy that will give you something to point to as people are coming back. Another key point, have employees provide their remote work location. You want employees to be working within the province in which you hired them or you're expecting them to be working. We want to avoid employees inadvertently becoming subject to the laws of another province or a country. We're seeing lots of people who've uprooted themselves and moved to, anywhere in the world, sometimes without their employer's knowledge, and there's risk that other laws would apply. And of course, we want to have people still within a commuting distance so that they can come into the office or workplace if needed. And really, again, set communication expectations, expectations around working hours and so forth. And of course, I'm going to have the usual caveat that regardless of what your policy says, from a human rights perspective, you have to sort of look beyond your policy and think about what you can accommodate in terms of flexible working. We'll turn quickly to the next section about sort of managing performance post-pandemic. When we think about monitoring performance and monitoring effectiveness in the workplace, you likely already have many of these practices in place. But again, as always, having clear and documented expectations and processes will set you up for success as an employer. And many of these points here you can think about as you're developing your remote or hybrid or flexible work policies. You can preemptively address a lot of common issues by setting out expectations around hours of work, response times, check-ins, and so forth. And, you know, any monitoring that you're doing, just a reminder, as Shane was talking about at the start of our presentation, think about whether you need to provide notice of any electronic monitoring to the extent that you're using that for performance evaluation as well. I'm going to just really quickly look at this employee absenteeism and work refusals. We could spend an entire day talking about how to manage employee absenteeism. On the slide, we've got some things to think about. Really think about whether there is a leave of absence under the applicable statute that you need to provide, that an employee might be entitled to, whether they're refusing to come back just generally or for a specific period of time. Consider any human rights considerations. Again, I feel like we've covered that, so I'll just pass over it briefly. Consider whether there's a legitimate refusal of unsafe work. There's work refusal processes in occupational health and safety legislation. You should probably already have procedures in place for dealing with that and investigating those work refusals. So think about that as you're evaluating whether someone has a legitimate reason to refuse to come in. Think about whether you have any other entitlements that an employee can use, whether that's sick time, paid time off, vacation, personal leaves, and so forth. And if all else fails and you think it's not a legitimate work refusal or not a legitimate reason to be absent or reason to refuse to come in, then consider what appropriate disciplinary measures you might put forward. And then on our last slide here, before we turn to the Q&A, as you are working through these issues and you wish to accommodate an employee beyond what they might be legally entitled to, setting aside any obligation to provide an accommodation on human rights ground, whether that's on family status considerations or disability or so forth. Think about how you're going to manage these issues internally to ensure consistency, to make sure that we're treating employees fairly and that there's a perception of fairness within your organization. And that will really go a long way for for supporting employee morale and giving you a really consistent approach for each case. And with that, I think I'll turn it to Katherine for some questions.
Great. Thanks, Rachel. And thanks to the audience as well for sending in some really terrific questions, both in advance and also throughout the course of today's session. Just for the person who asked whether this is being videotaped, yes, it is. And we will be making this available to folks in some fashion. Shane, I noticed a question came in from the audience in connection with naloxone kits. Do you have any information as to whether retail and distribution centers would have to have such kits on site?
It's a good question, and it's not specifically in the amendments to the Act. What an employer would have to do is an assessment of whether or not there is a risk of overdose, and if there was a risk, then they would have the obligation to have the kit.
Thanks, Shane. Alix, a question came in respect of the Amazon survey that you were talking about, and I have to say this caught my eye as well. Whether you are aware as to whether the answers that were provided were captured on a generational basis, where Gen Zers and millennials and boomers answering it differently? Has that been captured?
I think, I don't recall that there was anything that was based on age. It was 1,600 office employees, but they didn't say, I don't recall them talking about the age specifically and how they came to their conclusions on that. But I certainly agree that, you know, in the other studies that I looked at, there was an ADP study last year, as well as some other studies. They did look at the fact that younger, less experienced employees were more inclined to come into the office than more older employees who had family obligations or elder obligations, who liked that flexibility of being able to manage their personal lives a little bit better by not having to commute into the office. Whereas younger people, they acknowledged, still had a desire to have more interaction and more mentoring. So I think that's a good question, Catherine.
Yeah. Thanks, Alix. Rachel, let me ask you this. What if an employee refuses to return to work when directed or mandated, just because they would prefer not to come in? There's no human rights considerations. What's an employer to do with an employee such as that?
Sure. Yeah, I think there's a lot of anxiety around this. How do we deal with this? What's our approach going to be? I think it really depends on how hard you want to push as an organization. Is this something that you want to do gradually over time, sort of have people ramp up their in-office attendance or not? So I think, you know, giving as much notice as possible to employees that you're going to require a return in office is helpful, both practically and legally. And then, you know, if you are going to take a hard stance and a hard line and say, yes, you have to come back, then you got to be prepared to, you know, go with it. And part of that is really thinking about whether you're going to put people on unpaid leaves of absence, or whether you're going to sort of deal with it more through a job abandonment route, where you say, you know, you've got to come back on this day. If you fail to return, you'll be considered to have, you know, voluntarily resigned your employment. And obviously there are consequences there. I think it's worth, you know, getting legal advice on those circumstances, thinking about whether you have a good basis to require everyone to come back in, thinking about what communications you've had all along in terms of working from home, and any arrangements that you already have in place or agreements outlining expectations before you make any jumps to ending someone's employment. Always a good point to check to reach out on.
Mm-hmm. Thanks, Rachel. Shane, staggering figures on potential liability or penalties that can be meted out to directors and officers under the proposed changes to the Occupational Health and Safety Act. Any advice to directors and officers out there who are facing these significant increased liabilities?
Yeah. It's changes that'll be in force in July of this year. And so it is something that directors and officers should be taking steps now to deal with. And it comes down to ensuring that you're taking due diligence to discharge your obligations. So understanding what those obligations are and making sure that you're fulfilling those obligations through some sort of documented system where you're planning, doing, checking, and then acting on any points of omission to ensure that there are no gaps in your system, and getting regular reports up from the corporation in terms of health and safety audits. I think those are some good first steps.
Yeah, thanks, Shane. Time for one more question. Al, I'm put you on the spot. What happens in a case where an employer has given its employees the right to disconnect and a manager needs an employee to work on something on an urgent basis? Is that manager out of luck?
Yeah, it's an interesting question. Certainly what the ministry guidance has provided is that if you put in a policy that employees do not have to work, and there's no exceptions in your policy that you can require it if it's an emergency and what that might entail, then the ministry will enforce that they're not required to do it. it's not clear to me, and happy for Shane or Rachel to jump in. It's not clear in the legislation. It's not clear in the guidance materials what exactly, they will order if someone says, hey, I don't have to work. I have this policy. It says that I don't have to work after my regular working hours. So my refusal to do it can't result in any reprisal action by the employer. So if the employer tried to terminate an employee because they refused to work when they had a right to, I think they would have a tough time showing that it's not a reprisal. So that's how I think it could play out.
Yeah. No,
Again,
that's
not very clear in the legislation. Misleading in the media too. Yeah.
Sorry, Al, it's what, misleading?
Oh, sorry. I was just saying, I thought it was misleading in how the media presented this legislation. So it's just not really clear what the ministry will do, and they haven't really provided detailed guidance on it. So we're hopeful for regulations, but right now I think you want to be careful what you put in your policy.
Yeah. Well, thank you very much, everybody. It's 3:30 Eastern Standard Time, and I wanted to thank all of you for joining us today, and to my fellow speakers, thank you as well. A reminder to everybody to please fill in your survey if you haven't done so already. We really do read the surveys and look to you for ideas for what you would find helpful. Our next webinar, as we've been suggesting throughout the course of today, is on May 3rd, and it will be focusing completely on disconnecting from work and the various considerations for employers. So please visit the Fasken Institute section of fasken.com to register, and as well, when you're registering, to provide us with any questions. Again, we read those questions and try to make sure that we capture the questions in the course of our materials. So thank you, everybody. Have a good afternoon. Take care.